Good Tuesday night. I am Thabo Mdluli and welcome to In Focus. The question of land reform under the spotlight tonight, a contentious and controversial issue in South Africa, with Parliament divided on how best to achieve it. So what are the stumbling blocks to land reform, according to business, and what changes are needed to achieve satisfactory land reform? CEO of Business Leadership South Africa, Busi Mavuso, joins me to unpack this thorny issue. To be a part of this conversation, WhatsApp your questions and comments tonight on 072-110-5584, or you can tweet us at Newsroom405. Good evening, Busi, and thank you very much for your time tonight.
Good evening, Thabo, and thank you very much for inviting me.
That's that right there. Failure to address land reform could lead to political and even social instability. Are we agreed on that particular fact?
We are absolutely agreed, and I think the clip that you just played now around the fact that the issue of land reform has to be done, and urgently so, because it is vital in terms of acting in the interest of South Africans, both black and white. Thabo, was sitting in an environment where we have the highest inequality in the world. And when you look at how the issue of land reform, if it were to be accelerated and implemented, how it can actually close the inequality gap, in terms of people can be given the land so that they can use it as collateral to generate loans and develop small businesses, for example, you will see how that can actually advance our socio-economic transformation discourse. So the more we delay the implementation of this issue, we are disadvantaging millions of South Africans in this country. And in this case, we're talking about more than 50% of our citizens. So we are in agreement as BLSA, that this is definitely an issue that requires urgent attention.
We agree it's a political imperative, but also I think another point of agreement is that the process up until this point has been painstakingly slow, right? What is behind that failure to meet target?
So, Thabo, it is very clear, that the issue is not a constitutional inadequacy, but rather an administration failure by the ANC government. And I think if the ANC government were to advance a different reason towards the lack of implementation in as far as the land reform issue is concerned, then we know that that is actually a cop-out. They are merely just shifting the blame because they failed to do what they needed to do. So as BLSA, we've been categorically clear that the state has a moral obligation to right the wrongs of our past by transferring land back to those previously dispossessed during apartheid. And done right, it will build an asset base among an important segment of society, Thabo, as I've already said. So it has largely been argued, Thabo, that the constitutional property clause, Section 25, hampers land reform, as it does not allow for expropriation without compensation, and that the compensation envisaged by the Constitution is unaffordable to the state. The point has also been made that the willing seller and willing buyer model of land reform, which contemplates market value compensation, is unworkable. But then these arguments are, as the submission that we've made as BLSA, are misplaced, because when you read the Section 25 of the Constitution, it, number one, allows for expropriation without compensation in exceptional circumstances. And number two, it allows for the payment of compensation that is potentially significantly less than the market value of the relevant property in certain circumstances. And number three, it does not require the willing seller and the willing buyer model. So the reason why we therefore have not implemented it 27 years later, you would see that it's got absolutely nothing to do with the Constitution and its provisions, in particular Section 25. It's got everything to do with the fact that we have set as this country within an environment where you had the land court that was not sufficiently staffed, to allow for the implementation of land reform to be done. The land claims court has been one of the most understaffed, courts with one permanent judge All the other judges were rotating, which means that the decisions kept changing and there was no stability. That is why we were sitting in an environment where only 7% of the land, at least as per the last count, has been restituted. So the failure of government, to pay special and particular attention to this issue has been, the reason why we are where we are. So we're sitting in an environment where least resources, were given to this department, as I'm saying, where there wasn't even a permanent judge.
My conversation about a month ago with the chair of the ad hoc committee on expropriation of land without compensation indicates that there's nothing wrong with the executive to implement, but what has been hampering the executive from implementing is this issue of the amendment that needs to happen in Section 25 to make explicit what is implicit. In fact, what Dr. Matolo Motshekga says, he says, as far as desirability and the need to amend is concerned, our democracy is both representative and participatory, and what this process reflects is actually the will of the people. In other words, it's not the party that wants to amend the Constitution, but they are being given a mandate by the people as Parliament to amend the Constitution. So this is a mandate that has been given by the people. So there is a majority in the country that feel that section has got to be amended so that what is implied, which you've just raised now, is made explicit for everyone to understand, and not just those who are in business, who are educated legally to understand what it means.
So, Thabo, leadership exists to give guidance to the people in terms of exactly what the Constitution says and what provisions are contained therein. So let me just take you through Section 25.2 and Section 25.3, and I want us to have a conversation as to whether these sections, provide confusion in terms of what needs to be done. So Section 25.2 of the Constitution provides that property may be expropriated only in terms of the law of general application for a public purpose or in the public interest and subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. So that's clear. Section 25.3 goes on to provide that the amount of the compensation and the time and manner of payment must be just and equitable, reflecting an equitable balance between the public interest and the interest of those affected, having regard to all relevant circumstances, including, number one, the current use of the property, number two, the history of the acquisition and use of the property, number three, the market value of the property, number four, the extent of direct state investment and subsidy in the acquisition of the beneficial capital improvement of the property, and number five, the purpose of the expropriation. Now, the Constitutional Court itself has on numerous occasions emphasized that Section 25, needs to be interpreted in a manner that balances the pressing public interest in reform and transformation as against the private interests of the property holder. So Section 25 should not therefore be interpreted in a manner that frustrates land and other reform. And Chief Justice Mogoeng was very clear in this. I think on one of the conferences that he had with Agri-SA, he put it that Section 25 must be interpreted with due regard to the gross inequality in relation to wealth and land distribution in this country, and the need to maintain a sensitive balance between existing private property rights and the pursuit of transformation that Section 25 was designed to facilitate. So the Chief Justice also noted that the obligation imposed by Section 25 not to overemphasize private property rights at the expense of the state's social responsibility needs to be paramount.
Yeah.
So it is clear, therefore, that Section 25 here is not a problem. Chief Justice Mogoeng and the Constitutional Court, if there were any cases that made it to the Constitutional Court, they are not confused, in terms of what they need to look at and what the section deems to achieve, in as far as land reform is concerned. So if we are saying anything else other than the fact that as this ANC-led government, we have failed to do right by South African citizens for the past 27 years, then we are actually not being honest. But of course, if you're going to sit for 27 years, Thabo, and not implement that which you were, or that which you had promised 27 years ago, you had better come up with the right excuse, or some form of excuse in terms of why you have not failed to deliver. And remember, we often do these things as this ANC-led government when it is time for elections. Right. So for me, it is also not surprising that we are now up in arms around the issue of the expropriation bill, around the finalization of Section 25, knowing very well that we are going to the local elections. And I think, they need to make noises that are going to resonate with the electorate, right? So it definitely is not the truth, for us to interpret.
We'll come back to that. Section 25 amendment, is it necessary for legal process, or as Busi Mavuso puts it today, is it just merely a convenient political rhetoric building up to the local government elections, which are set to take place in October? Give us your views tonight on Twitter at Newsroom 405, on 072 110 5584. That's the WhatsApp number. Business Leadership South Africa CEO Busi Mavuso returns on In Focus in a moment. Back with you on In Focus. The conversation continued. Business Leadership South Africa CEO Busi Mavuso, listening to the chair there of the ad hoc committee on land expropriation. I see you smiling. That is the argument, right? The counter argument to what you're saying is that this is a process for legal certainty, right? So that if you bring in 100 lawyers into a room, all of us can have the same interpretation of what is being expressed explicitly in the Constitution.
Thabo, I would accept that excuse if maybe we had found ourselves in that, environment, as South Africa, where we were saying, we really want to do this, but the problem is that all these lawyers are coming up with different interpretations of what Section 25 means, right? So I think all of this is theoretical, and I'm listening to this very good, eloquent English, and that's all it is, Thabo. It is just good English, make that which is implicit, explicit, it's really gibberish, to an average South African. It means absolutely nothing. They want to see you implementing this thing. So, Thabo, let me make reference to this. Our submission as BLSA that Section 25 does not require amendment is also consistent, by the way, with the outcome of the ANC's Land Summit, which they held over 2 weekends in May 2018, in which it resolved that Section 25 ought not to be reviewed, but should rather be tested before our courts to determine whether the Constitution may allow for expropriation without compensation. And the ANC National Executive Committee subsequently ratified this resolution, and this was announced by the Secretary General, or previous Secretary General, Ace Magashule at the time, on the 29th May 2018. So the problem with this issue is that in 2009, when the ANC moved away from the willing buyer, willing seller model, which was deemed ineffective at moving enough land at the speed the ANC was looking for to expropriate, there was no policy on reform, or rather on land reform, that was put in place. And the 2008 draft land expropriation bill was shelved, until it was brought up again, with the current 2016 bill, which is rather inclusive and has subsequently been gazetted in 2020. That is what is confronting us as South Africa today. That is the reason why the land reform has not moved, not the English of implicit and explicit. There is nothing like that. As I'm saying, in 2018, even the ANC itself has said that there is no problem with this thing. If we wanted to test, if really, there is confusion around it, it needs to be tested at the court. Yeah. So I think this interpretation...
There are some would say, well, the business would say that there is no problem with interpretation because they fail to understand the degree of land hunger in this country. But Noma Ranjan, we are going to amend that constitution. We are going ahead, and there is no business in this country that's going to tell us otherwise, because after all, it's in their interest that we don't get land, because some of this land is actually owned by business.
But you see, it cannot be true that it is in our interest that people don't get land, right? Because we support Section 25 as it stands, and I think I've just outlined that Section 25 is actually very clear. It provides, for expropriation without compensation in exceptional circumstances allows for the payment of compensation that is potentially significantly less than the market value of the relevant property in certain circumstances and does not require the willing seller, willing buyer model. But the problem for us as business, Thabo, is the fact that the amendment of Section 25, gives the country a certain degree of policy uncertainty. We're sitting in an environment where we are trying to drive the economic recovery agenda. We're sitting in an environment where it is difficult for not just local investors, but for foreign direct investors to come and invest in the country, precisely because we don't have a conducive environment within which business should operate. Now, if we understand, Thabo, and if we appreciate that the only way in which South Africa can get investment is by increasing business confidence. And you can increase business confidence if there's policy certainty. And we are not saying we want to like the policy that is implemented. We are saying, can we know what we're dealing with? So the longer you leave the issue of Section 25 open-ended and not concluded, it therefore provides that uncertain environment. I mean, you and I saw today, and many South Africans, the clover, a factory in Lichtenberg, moving its operations to Durban. And we should be thankful that they are actually moving it to KZN, still within South Africa, because many firms, Thabo, are actually shutting their operations in South Africa, and they are moving to Kenya, to Rwanda, to Ethiopia, and whatever the case is. Because capital is very clear that they are going to move to areas where there is least resistance when it comes to a conducive environment within which they are operating within. So we fail to understand, therefore, as a country, that the interest of investment in South Africa has got nothing to do with South Africa in and of itself. Because remember, our market is only 60 million people. And when you look at the unemployment of 42.6%, you will see that it's not actually 60 million people, it's actually a lesser number. So the interest of capital in South Africa is in as far as South Africa is a gateway to the African, continent, because they are interested in the 1.5 billion people that exist in the continent, not in South Africa. So policy uncertainty, therefore, and what section or what the amendment of Section 25, whatever it's going to look like, is going to mean for investment is rather worrisome. And we need to ask the question.
One would say there is already policy uncertainties, as Busi would say. For example, if we speak of expropriation without compensation or expropriation with nil compensation, and whether or not that takes away the right to just and equitable compensation. These are issues that are currently under review in this process, so as to give us that policy certainty, so that we know that when we talk of expropriation with nil compensation, what exactly are we talking about?
So already the Section 25 as is, Thabo, makes provision that if the circumstances are just and equitable, compensation may be nil. Right? So it therefore means that there's not going to be any forced removals. It therefore means we are not going to go, the way of Zimbabwe. It therefore means, there is going to be structure in terms of how South Africa is going to actually implement, its land reform policy. Actually, I don't know if you saw towards the end of 2020, a political and economic risk consultancy Unomics was quoted by Bloomberg as saying South Africa faces a quick economic and political collapse by 2030 unless it changes its economic model and implements growth-friendly policies. They were actually saying that we will be a failed state by 2030. Now, if you take that into account, and if you take what's happening, if you take the investment that is currently being, cancelled, redirected, or actually, taken away completely, you will see that it is not far-fetched, that South Africa will be sitting in that environment. So I think capital understands Section 25 as is, and they are not in dispute. They understand that if the conditions so require, compensation may be nil, if as I've said, the environment or the conditions are just and equitable. But then this amendment, gives that uncertainty to say we don't know what it's actually going to mean. Yeah. And I think the uncertainty also stems from the fact that if you listen to what an EFF is saying, for instance, they are not talking about nil compensation. They're actually talking about forced removals. So politicization of this issue by your EFFs is unfortunately not helping, and this raises concerns rather that the land reform process will lead in a dramatic collapse of the economy.
Now, let's talk then a little bit more about that case for investment around property rights. And this is one of the issues that were articulated by the chairperson of the ad hoc committee on land expropriation without compensation, to say that there are certain things, for example, that go with land. So the question around water rights certainly will go with land. But on the question, for example, on what the preamble says on improvements, that is where there is an opportunity for business, private individuals and the public at large to make submissions on what exactly would be deemed as improvements and movable property.
So from where we are sitting as BLSA, we are very clear that if the Constitution is amended to provide for expropriation without compensation for purposes of land reform, then BLSA submits that such an amendment should have the following key characteristics. It should apply only to land that is expropriated for purposes of land reform in circumstances that are set out in the national legislation, number one, and number two, the courts should retain the power to determine the amount of compensation that is payable. And number three, the payment of nil compensation is only permissible in circumstances in which a court finds that such an amount of compensation is just and equitable, having regard to all relevant, circumstances. So I think we are very clear that if you therefore, are going to include all other assets in the expropriation without compensation, I think that therefore, leads, to this uncertainty, that I'm actually talking about. So other than for the fact that the draft bill only applies not only to land, but also to improvements on land, it appears to us that the draft bill intends to adopt the characteristics that we have actually set out, as BLSA, and that we'd like to see. Nevertheless, as explained, by BLSA in its submissions, we are concerned about the manner in which the proposed amendments are worded, and we actually believe that the wording could actually be improved in certain respects, so that it is clear that we are actually seeking to expropriate land for purposes that will advance the socio-economic transformation agenda of the country, so that we don't really, in that category of assets or in the category of land, include all other things that, as I'm saying, would actually make businesses, capital and investors uncomfortable.
Who should lead the process of land reform? That's the question we tackle next with the CEO of Business Leadership South Africa, Busi Mavuso. Taking some of your questions coming through tonight on WhatsApp when In Focus continues next. Right, you're back with In Focus now. Newsroom Africa, Channel 405. The conversation tonight, Business Leadership South Africa CEO Busi Mavuso talking land expropriation without compensation, saying the problem is implementation, not the Constitution. What are your views tonight on 072-110-5584? Or otherwise, you can throw us your comments at Newsroom 405. Who should lead the process? You already mentioned earlier on that should let the courts decide. It's the view of this ad hoc committee, I suppose some in it, and some have advanced the view that actually the executive should lead that process only when there is a dispute. Should the courts then be brought in?
Thabo, can I come in?
Yeah, you can.
Yes. Okay. All right. I wasn't sure if you were going to play a clip or if
no.
responded at this point. So, Thabo, the measure clarity that the current bill provides is in stating that the amount of compensation will be determined through the courts. And this is in line with the World Bank recommendations, by the way. And this move is definitely welcomed because remember that the ANC has once called for that power to be placed in the hands of the executive branch. And I can tell you now that that would have been disastrous. So the bill, however, is open-ended about who can do expropriation without compensation and at what level of government, that can be done. And we think that this is clarity that actually needs to be provided in the bill so that we don't leave this hanging. And the bill therefore also contains important checks and balances on how expropriation will be done, and the procedural requirement in the bill states that government can engage in expropriation without compensation only if negotiations to buy property on reasonable terms fail. So it gives clarity that the expropriation without compensation is not the main lever, for land reform, so we should therefore, ensure that we keep this in mind. So I think the brilliant thing about the bill in terms of, providing further clarity is that it clearly lays out 5 circumstances under which private property may be expropriated without compensation. And it says, Thabo, that where land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from an appreciation of its market value. And then number 2, it says that where an organ of state holds that land that it is not using for its core function and it's not reasonably likely to require the land for its future activities. And number 3, it says where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. And number 4, it says where an owner has abandoned the land by failing to exercise control over it, notwithstanding the registration of ownership in terms of the Deeds Registers Act. And the last one, it says when the nature and condition of the property poses a health, safety, or physical risks, to persons or other property. So there is that clarity, therefore, that is provided. So I think at the moment, in terms of, the draft amendment bill, there is no confusion. Yeah. So, and business is in support of this. So, Thabo, we are not mistaken and we are not confused, this business. And I don't think that the current narrative, actually advances our position, as we intended, because we are very clear that the process that we need to embark on in as far as land reform is concerned, needs to be a social justice process. Because our country requires it.
Yeah. As far as the implementation challenges are concerned, what's the position on business on whether or not an independent body should be set up that will implement the land reform process? Because in my conversation with the Eto Committee chair, again, it seems his view, I suppose it would still be canvassed amongst all the parties, but his view certainly was of the nature that said, well, now you want another body, more money, right? More taxpayer money is going to be used to set up this office when he feels that the executive or cabinet or the state has adequate capacity to be able to handle this process.
Thabo, as a country, as you would know, that we have already drafted a copy of the new land court bill. And it has already been published, and it's very clear that this new land court bill, or that this new land court, rather, is specifically aimed at accelerating the country's land reform program, as well as resolving the backlogs and disputes around land claims. So I don't know, therefore, why we would want to go and set up a parallel process. Thabo, you and I know that one of the critical things that continues to hold South Africa in good stead with all the problems that we have, as a country, and what sets us apart, from our other sister African countries is precisely that we've got a strong and alive judiciary, and you've got capital and investment which really trusts our judiciary and believes that, our judiciary will do what is right, for the country and will not in any way disadvantage, one party over the other. So if you want to therefore set up some body, that is actually going to be looking at this, what are you trying to achieve? And why have we gone to the process of actually putting together, this land court, so much so that we've even drafted a bill, that is actually going to give the terms and conditions under which the court is actually going to operate. So for me, it actually doesn't make sense. And I worry that it is such noises, that therefore give confusion to the market, and that doesn't therefore bolster confidence. We are sitting in an environment, Thabo, where the president is currently in the UK or, on his way to the UK to attend the G7 summit. And we know that one of the conversations that he seeks to have with a G7 constituency is that South Africa is ready for business. That South Africa is a strategic investment, destination. But he's therefore going to have to answer difficult questions, around the land issue, around energy security, around the auctioning of the spectrum, and. So if we are therefore not clear as a country in terms of what it is that we want to achieve with the amendment of Section 25, as well as with the expropriation bill or with the land court that we're establishing, it's therefore going to, make the case or the business case for South Africa as an investment destination a very, difficult one. So for me, I absolutely don't agree with the notion that we actually have to set up some independent body. Give this to the courts. There's already a lot of credibility in our court system. So give this to the courts and let the courts, embark on it and undertake, on this issue the way it should.
All right, let's take some questions in on WhatsApp tonight, Ted. This is what our viewers are saying to this conversation on expropriation without compensation. Albert in Robertson saying the attitude of government to ignore indigenous people will always lead to slow land reform or land reform for the elites. The land reform that suits the Eurocentric plans cannot be for Africans. As long as we are beggars in our own continent, nothing will be sustained. Let's take more. This from JST in Klerksdorp. Thabo, can you please ask Busi, in cases where landowners refuse or reject any offer below the market value, what should the department do? May we please have practical solutions or recommendations from her. Let's dive into that one. There is, of course, price setting. We must admit that, in a sense, has delayed the process of land reform in the past. What should happen when the owner would not agree to the market value that is being offered by government?
So, and Thabo, as I was actually saying earlier on, that this is actually made very clear, by Section 25, as it actually stands, and they are very clear, that Section 25 is actually not going to be applied in the interest of private properties. As I said, Section 25(2), says that property may be expropriated, for application in terms of the law of general application for a public purpose or in the public interest. So I think that in there, says it all, that this is actually going to be done in the public interest, not in private interest. And I think I also alluded to the fact, that Justice Mogoeng, was also very clear, in terms of what their position is as the Constitutional Court. So even if we were to find ourselves in a situation where the private owner is not interested in engaging in this issue, the Constitutional Court is already saying that Section 25 must be interpreted with due regard to the growth inequality in relation to wealth and land distribution in this country, and the need to maintain a sensitive balance between existing private property rights and the pursuit of transformation that Section 25 was designed to facilitate. So there is no confusion. None of us, dispute the fact that what we are embarking on is a social justice issue, Thabo, not an economic, process. So this is not a process that seeks to enrich, certain few individuals, at the expense of the rest, which is why the willing buyer, willing seller, notion was actually abandoned, in 2009, because it saw that this actually continues to enrich a few, at the expense of the most. So I think our constitution as it stands, and the law in the Constitutional Court, is not confused, in terms of what we're trying to achieve with Section 25 and what it is that needs to be done in looking at those cases where private owners are actually going to be difficult when this needs to be implemented.
Right, another question coming through tonight asking you to expand, they say, on your theory of politicians using expropriation or amendment to Section 25 as political rhetoric for local government elections.
It's interesting for me in terms of we have failed as a country for the past 27 years to deal with this issue. But also, if you remember how or when, Thabo, we came up with the fact that Section 25 needs to be amended. If I'm not mistaken, it was not the past elections. I think it was the elections, before that. I think, if I'm not mistaken, which I think it was around the second term of President Jacob Zuma. So when you look at, and I mean, I've already gone through the sections over and over again and what the Constitutional Court says, in as far as the interpretation of Section 25 and I think it is clear, to all of us, that there is no confusion in terms of what Section 25 is trying to achieve, and what it is that needs to be done, even when the private owners are actually giving the process a problem, as it were. So, but the fact that you always get, the politicization, of this issue, around or the times of elections, it's not by default, but it's by design. The same way that we decided to pass a resolution of free education just when Jacob Zuma was about to step down. If I look at it, it was really a populist stance. Because when you look at what our Constitution says, there is no confusion, in terms of the fact that all South Africans have got the right to free education. And I think there has been numerous conversations within the ANC in terms of looking, at how we can implement the issue of free education. But for whatever reason, like with many things, the ANC had actually not paid this attention. What they've actually chosen to do was to drive their own narrow agendas. For the past 15 years in this country, we've been actually, under the state capture. If you look at the millions of rands, not millions, billions of rands, we can't even quantify it. We don't know how much it is. The billions of rands that have actually been siphoned out of the country that could have done precisely these things, that could have made sure that the land court, is appropriately, staffed, that we have judges that are actually going to accelerate, Section 25 for the implementation of land reform, where we could have given free education, to South Africans. And, there are many things that we could have done, but I failed to do, because we were pushing our own narrow interests. So I think let's not be confused, what the agenda is here and what the issue is here. Let's also not be confused, in terms of what Section 25, seeks to achieve. There was absolutely no confusion when we as a country, in writing this constitution, what we wanted to achieve in as far as the land reform is concerned. Because remember, Thabo, this was the big ticket and policy issue and agenda of the ANC when they came into office in 1994. Right. They knew that they need to actually redress the past imbalances and actually need to deal with the 1913 Land Act. Right. So we were not drunk when we amended or when we wrote, the Constitution and we put in Section 25. So it allows us to do what we needed to do, but we keep on bringing it, during election times, because as a country, we've failed to do what we needed to do over the past 27 years.
CEO of the Business Leadership South Africa, Busi Mavuso. Appreciate your time and thank you very much for joining us tonight on In Focus. And thank you for participating tonight in the conversation. Well, there you are. We were not drunk 27 years ago when we set up this constitution. And don't be fooled by what she says is just absolute gibberish. In Focus continues for you in a moment. Stay with us.